Hello, everyone. My name is Tina Searing. I'm a partner at Husch Blackwell in Minneapolis. And welcome to Navigating Mold and Contaminated Building Litigation. This is the first of a 6-part series that we're kicking off today. As I said, my name is Tina Searing. I am an employment litigation attorney, but I also have significant experience in toxic tort litigation, representing property management companies and landlords throughout the country, involving claims similar to what we're going to be talking about today. This work includes aggregate and class litigation where the alleged damages involve often multi-million dollars. Before we begin, I want to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use today during the program. If you have questions during the webcast, please submit them through the question box. We will do our best to answer all of your questions during the webcast today, but if it requires a fuller response or we run out of time, we will follow up with an email to you. A PDF is also available for you in the program materials folder that you should be able to see as well. Auto-generated closed captions are available for today's program. To turn on closed captions, click the CC button in the bottom right corner of the media player box. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance will, including the course numbers, will be emailed to you tomorrow, along with the recording of the webcast for watching and sharing. And toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And with that, let's get to the program. I'd like to introduce the speakers with me today. Michael Klevanoff, who's a partner in our Washington, D.C. office, Rick Morgan, a partner in our Minneapolis office, and Hal Perloff, a partner in our D.C. office. Michael defends landlords and other companies in suits across the country, including defeating the types of claims that plaintiffs use in mold and contaminated building litigation. He has experience defending against these lawsuits and arbitrations from Hawaii to the East Coast and focuses on class action and appeals. Next is Rick Morgan, and Rick primarily represents private companies in high exposure toxic tort cases, including exposures allegedly resulting in death. He routinely handles complex multi-plaintiff and class action cases and has tried bench and jury trials across the country in more than 20 states. Rick's experience also includes representing of insurers in toxic tort cases, and he's decades of experience in defending mold litigation matters. Finally, Hal Perloff. Hal's practice focuses on representing contractors and subcontractors in complex government contract disputes. He has extensive experience in privatization and outsourcing, having handled a broad range of compliance issues and disputes arising under the Military Housing Privatization Initiative. This includes representing property owners, landlords, and property managers in toxic tort and mold litigation and arbitration with service members and their families. And with that, to cover today's agenda, we're going to talk about the overview of these growing claims, no pun intended, the plaintiff's counsel strategies, which include advertising, social media, advocacy groups, single and aggregate and class claims, and their litigation strategies. We'll also briefly touch upon insurance issues, crisis communication strategies, steps to minimize the threats of litigation. And with that, I'm going to turn it over to Michael on the overview of these growing claims.
Thank you, Tina. So, hopefully everyone can see this picture here. And, Tina said that the overview of these growing claims is not a pun intended, but the mold itself is an analogy here. If you want to understand, looking at this photo, what you see, what those conditions are, how to take care of them, how to remediate them, how to address them, you sort of need to know, or it's very helpful to understand why it arises in the first place, right? What are the conditions for mold that let it grow? Happens to be organic material and dampness. We'll talk about that at another point. But the same way that understanding how mold grows helps you actually deal with mold itself, so too with the litigation. Understanding the conditions that are giving rise to more and more of this litigation helps contextualize and help us understand how to actually deal with the litigation most effectively. So with that primer, let's get into the specific of why these types of claims are growing. You see 5 different dimensions here. Let's take them one by one. First, the media coverage. This media coverage has been both local outlets and larger, what we might think of as mainstream outlets, so like Reuters, CBS. A lot of this coverage percolated after a congressional hearing some years ago that focused on housing conditions for major landlords. And that media coverage, although perhaps not as active as it was during the congressional hearings, continues and started a condition where many more plaintiffs' counsel were interested in this landscape. So let's move to the second part of the spectrum, the pandemic and working from home. Now, the working from home has 2 different aspects here that were important to this environment. First, people generally were spending more time at home in a context where they are thinking more about what they're breathing, what they're exposed to, what's in their home, and less so than they would be in a commercial setting generally. The second part of this is that has them thinking about, and plaintiffs' counsel thinking about this, and then translating to potentially how juries might be impacted by it. Now let's move to the middle of the spectrum, and you see public awareness of airborne pathogens. This really has a lot to do with COVID, masking, the debates around masking, and the understanding of the science behind inhalation of airborne particles during COVID. Because of that public discussion and understanding, inhalation grew in some sense in terms of what was perceived as a distinct threat. Now that's relevant to something like mold or other contaminants where, for example, with mold, in fact, ingesting mold is a much higher risk and much worse, especially if you're dealing with mycotoxins, which we will talk about in a different segment in 2 months when we talk about mold science in particular. But there are different ways of interacting with mold that are more dangerous, but the inhalation and the public discussion of inhalation of other pathogens made this understanding of mold or this consideration of it more part of and more interesting to plaintiffs' counsel. So let's move now to the 4th part of the spectrum, perceptions of landlords and property management companies. Now this hasn't distinctly changed with one specific event, but we know that these entities have frequently, and we've seen they've frequently been targets for plaintiffs' counsel through claims like asbestos claims. And this presents another, by this we're talking about mold and contaminated litigation, presents a new avenue for those counsel. So we get to what this all culminates in, the last part of the spectrum, verdicts. What we saw is some decades ago, there were some large multi-million-dollar verdicts. But as junk science had a bit of a falling out, and the actual science, the accepted science on mold dominated in the courtroom, those large verdicts mostly disappeared. But within the last few years, in part due to the other conditions, the 4 in the spectrum we just talked about, there's been a resurgence, not just in the lawsuits, the arbitrations, but the verdicts themselves. Just last year in Travis County, Texas, a Texas jury returned over a $3 million verdict. And there are other types of verdicts that are in the millions of dollars that are out of the norm with what it used to be decades ago, but are a sign of a continuing growth industry for these plaintiffs' counsel. And with that in mind, I'm going to turn it to Hal Perloff.
Thanks, Michael. So who are these plaintiffs that are bringing these claims? Well, plaintiffs' counsel, of late, they are looking for people that are likable, relatable to a jury, sympathetic to a jury, people that may be perceived by a jury or an arbitration panel as vulnerable, as not particularly sophisticated or well-informed, and people that plaintiffs' counsel will portray as not having people we don't want to have to worry about living in safe conditions. So think families with small children. They're going to play that up. Think students living in student dorm housing. Think retirement homes and grandma and grandpa. We want them to be in a safe environment that keeps them healthy. These are all the angles that a plaintiff's counsel is going to play up. They're going to play up the sympathy and vulnerability of these populations. And as defense counsel, it makes it a real challenge because these are people that a jury isn't going to look real kindly on us if we are real aggressive with them in cross-examination and trying to suggest maybe they're faking a symptom or it wasn't as bad as it seems. That can obviously come across as callous and hollow, and plaintiff's counsel are very skilled at leveraging those sympathies and that perceived disparity of power. So who are the defendants? And we'll have a poll question about this in a second, but I'll address this at a high level. You can see, and I think we have representatives from many of the folks that are in these industries on this call today. So thank you for joining us. But these are the examples of the kinds of entities that can be named as defendants. And what makes them attractive to a plaintiff's counsel? Well, they are perceived to have deep pockets. They are perceived to be in a position of authority or control over the plaintiff. So they're the landlord, they're assigning housing, they're running the nursing home, you name it. These are organizations that are going to be perceived to have resources and potentially the opportunity and the expertise to take care of the plaintiffs. And a jury's going to want to believe it's their responsibility to take care of the plaintiff. And again, plaintiffs' counsel are going to be very careful in crafting a message that emphasizes sort of that disparity between the landlord who wrote the lease, who is responsible for cleaning up the homes, and a brand new tenant who this is the first time they've ever lived in an apartment. They're going to leverage that and leverage the difference in power and dynamic there. So with that, I think we have a quick poll question. So you guys can just click on the answers. I'll go through it, but we are curious for our future planning purposes, just to get a sense of who all is on here. Which one of these best describes you? So you can click on the right answer. Click A, please, if you're a landlord or a property owner. You can go ahead and start clicking now. See those answers are starting to come in. B, if you're in property management. C, if you're a contractor, a builder, or a remodeler. D, if you're on the insurance side of the house. E, if you're other. And F, if you represent sort of multiples of these categories. So I'm just going to give you another few moments here to answer. I see a little more than half of people have answered. Let's just give it another second or two. And let's see. So it looks like out of the sort of the classic categories, we have a lot of owners here. And I believe also we have a lot of others. So thank you all for responding to that. And next slide, I'm going to turn it over to Michael.
Thanks, Hal. So I want to talk now about the types of claims that the plaintiff's counsels bring in these cases. And we have a bit of a laundry list because sometimes these complaints in these cases are more narrowly tailored, but frequently they take a kitchen sink approach. And it's worth our time to talk a little bit about each of these in a quick way. So first, breach of contract. That one is very frequently in these complaints There are some important nuances. Frequently, you'll see is only some defendants are actually potentially liable under the breach of contract, and other defendants might have unique defenses about privity or who signed. Negligence is the one that's most likely to get to trial because that's where the causation story it comes through, and that's where a lot of the case really gets tried. Nuisance is not as frequent as the first two. That is in part a product of many state laws or decisions of those state courts that limit the applicability of nuisance to these types of situations. When I say these situations, I mean frequently landlord-tenant situations or relationships will not be subject or available under nuisance law. Fraud and deceptive trade practices, those frequently go together because fraud, we're thinking about common law fraud, so it will be paired with the consumer fraud statutes or the deceptive trade practice statutes. And although they're paired together frequently, the statutes tend to be a greater risk because depending on the state you're in, they come with a lot of different aspects. So one, a lot of the statutes have automatic damages provisions per violation. And we'll talk soon about what are the types of damages. But again, some of these state statutes will say per violation of the statute, there is an automatic minimum amount for each violation. And at that level, damages start to go up very quickly. Now, other statutes have automatic trebling. Not quite automatic, but the violation just has to be knowing. So not malicious, not intentional, not like what you see in punitive damages, but just knowing, which creates a much lower threshold for damages going up much more quickly in terms of the threshold and proof. Some of them also have attorney's fees provisions, and many of them have unique defenses like pre-suit notice and other types of defenses. Habitability is one that more frequently shows up in these complaints when there's more than just mold at issue. So if you have accusations of infestation or vermin or something else that creates an environment where it's easier for plaintiff's counsel to paint a picture of this home was not even one, or this apartment or whatever dwelling it might be was not even one where someone could live because it wasn't habitable. As you move over to the right-hand column, these become less frequent in the complaints. The landlord-tenant statutes, though, when they exist, they are frequently pled because in many instances, they cannot be waived by contract, or there are at least sharp limitations that state laws provide for waiving those or limiting liability under those statutes. And you see a little bit of here in the last bullet, the other types of claims that are included. I'll just note that the conspiracy or RICO category is sometimes seen as a sexy category for plaintiff's attorneys who don't fully appreciate that claim. And that claim has a lot of important defenses that even though there are multiple defendants talking about the types of facts that are here, that does not make a RICO conspiracy claim. So we've talked a little bit about the claims here. Let's move to what damages might plaintiffs or plaintiffs' counsel allege. You see 6 different categories. Let's take them one by one. First, on the economic damages, that usually falls into 3 different buckets. One of those buckets is household goods that are damaged or not replaceable. We'll talk later today about what that means. A second is the purchase price or the rental payment that a plaintiff will say they should not have paid at all because of the conditions in the home, or at least they should have paid less, they'll argue as part of their damages. Although usually they're just arguing for the full amount because they'd rather go for broke rather than suggesting a more reasonable position. And the third bucket there in economic damages is lost wages, which again, we'll talk about more later. Second bucket, you've got physical injury. This is what you traditionally think about in terms of your medical bills, your doctor bills. This category in actual numbers ends up being smaller because of insurance coverage. Because plaintiffs can't ask for what insurance covered, they're typically only talking about what they paid for out of pocket for their physical injuries. The third bucket, mental anguish. This is where a lot of the bigger risk, the verdict and dollar risk, comes up because it's relatively amorphous. A lot of nebulous concepts like anxiety, stress, trouble sleeping, and the things that we all experience to different degrees can all fall under this bucket. Now, what's important about it is although it creates a bigger risk, a causation proof still applies here. So there are still important defenses that come up even with this area or this bucket of damages. Next, we see statutory damages. We talked a little bit about how different statutes in different states can create an automatic statutory damage amount based on each violation. And what that means can depend on the state and the court. Fifth, we see the punitive damages category. What's important here to flag is we all generally know that the conduct needs to be outrageous or a similar type of level of conduct to be enough to get to punitive damages. But as we've seen, pictures and testimony can tell a different story than what it looks like on paper to a jury. So even though something from a pre-litigation standpoint might look like it would never get to this level, when there is a certain picture or a certain testimony that plaintiff's counsel have worked through, that will create a risk in this category as well. And finally, attorney fees. This is frequently a product of the statutes that we just mentioned. And one thing to note here is, although there's usually a contingency arrangement between the plaintiff's counsel and their clients, they still, that is the attorneys, still will be seeking their hourly fees. Sounds like it might be double dipping. It is, but they'll still seek it, and that still creates an extra risk in terms of damages. Now we're going to turn to Tina.
Thanks, Michael. So we're going to talk about a bucket of plaintiffs' strategies, and in particular, what plaintiffs' counsel strategies have been and that we've experienced. To start with, we see a lot of advertising strategies. We pulled some examples, but the advertising is not just online or when you Google a law firm. And a lot of the law firms that we are seeing handling these types of litigation come from personal injury background. But their advertising is things like the value of my toxic mold case. So they're giving that phrase toxic, that sounds really bad. You see, what is a toxic mold personal injury lawsuit? Again, toxic, that sounds really bad. Suing your landlord for black mold, that sounds really bad. Common symptoms of toxic mold exposure are your health problems related to this? How is toxic mold exposure diagnosed? Solid evidence you need, lurking peril. These are all examples of what we're seeing in terms of the advertising, which in turn has resulted in the growth of these types of claims. We also see advertising on television with plaintiffs' law firms in southern states where there's a higher level of humidity. And similar, I was in Florida for a vacation, and I happened to see a number of television advertisements about toxic mold and mold exposure and how bad it is. And so there's this strategy of this is really bad and I need to go talk to a lawyer, rather than working with the landlord or the property management company about a remediation or an abatement. Instead, we're seeing they're suing because they've been told that this is toxic mold and it's really, really bad. Another advertising that we see, or strategy we see, is a lot of social media. We pulled some of this together. And we see social media not just by plaintiffs' attorneys, but also people that are working with plaintiffs' attorneys, who plaintiffs' attorneys have built a network of mold inspectors, that they call them, or mold doctors. And so they're sending the plaintiff's social media. You'll see things like, my wife is a badass. This was on LinkedIn that we pulled this. Last week, she won a mold injury case, which was one of the largest verdicts in Williamson County of Texas. It's not just trial work, it's precedent, changing the law, because we're doing good things. That's one of the social media. Or that mold cases are tough to litigate. And so that's another, we saw this on social media. This was on Twitter that we saw a tweet. The other one, that the top symptoms associated with mold and mycotoxins, that was on Instagram by one of the mold doctors and how to treat it. And what's been interesting is that this network has been created where maybe the mold inspector will come out, and we've had some cases where there's been mold inspectors involved in some of these plaintiffs' cases. And Rick and I had a case where the mold inspector came out and he said that every home he inspects, he finds mold and the house is uninhabitable every time. it's uninhabitable, and a full remediation and full abatement. And then guess what? There's a network where that mold inspector will send them to, there's a referral source to the lawyer, similar to a referral source to the plaintiffs. Maybe the plaintiff lawyer has somebody that they lined up who they say that this is a doctor that can handle mycotoxins and mold. And this is through the social media that we're seeing this network. Another strategy that we see are advocacy groups. And some of these are on social media, but some of them are also grassroots advocacy groups. Some of them are in multifamily, multi-residence communities where they're dealing with the same type of builder, remodeler, or you're dealing with the same type of property management company or landlords. And so we've seen some grassroots advocacy groups form. One of the things Michael talked about was in the growth of the mold litigation and this contaminated building litigation is congressional testimony. We know that some of these grassroots advocacy groups were playing a part in congressional testimony. But you also see, so like this example of the toxic mold support group, this happens to be a toxic support group, an advocacy group that started by a doctor. And this doctor then has, again, a network of lawyers that they can connect you to. The Great Mold Escape. This Great Mold Escape is another example where they're here to help you, and then they provide the resources to you of here's the inspector you need to have, here's the at-home testing kits you should have, here's the doctor you need to go see, and here's a Facebook that you should be posting to. So it's an advocacy groups on social media, and the advertising has really created the growth, helped growing this type of litigation. And so with that, another strategy is the litigation strategy. So I'm going to turn that over.
Thanks so much, Tina. I'm Rick Morgan, and our team is now going to turn to talking about plaintiffs' counsel's litigation strategy. And we have the good fortune of having had many years of experience to successfully battle these strategies and try to bring these cases under control. So let's turn first to the aggregation of claims and class actions. So while many mold and building contamination cases involve a single plaintiff, plaintiffs' counsel usually try to aggregate their claims. What's the idea? More people, more problems equals more damages. Plaintiffs' counsel will claim to the court that aggregation will result in what we call in our business judicial economy, the idea that handling a large number of claimants in one proceeding is more efficient. And it's important from a defense perspective to avoid aggregation of claims. If we look to break up the cases so we're dealing with just one plaintiff and one structure at a time. We look to show that every claimant, every building, every residence present different issues. We tell the court that if you aggregate these claims, you could end up with no efficiency at all. You just have little mini trials for each claimant or building. And so to combat aggregation, we normally will bring what we call a motion to sever, as we recently did, Tina and I did in the Northern District of Texas. We broke multifamily complaints into separate cases for individual families and individual residences. We argued that aggregation risked prejudice to the defense and invited juror confusion. With aggregation, the jury can lose track of the ability to individualize the evidence related to separate plaintiffs, or in that case, separate residences. And we were successful in breaking those cases up, and it allowed us to achieve a much better resolution than I think we would have if the cases had been aggregated. Let me turn now to talk about class actions. A class action is simply a procedural device that permits multiple plaintiffs to file and prosecute a lawsuit on behalf of a large group or the class. It's an aggregation on steroids. We defeated an effort to certify a class action in mold cases just about a year ago, last February 16th in the Eastern District of Virginia. We were defending Fort Belvoir residential communities on a military base out there. And the plaintiffs tried to aggregate the claims of over 60 plaintiffs. And so we argued to the court, and were successful in doing that, by saying the class claims did not meet the requirements for a class action, particularly the requirements of what's called commonality, the idea that the class members share common legal or factual issues. Again, the idea is each resident, each plaintiff will have different claims, different claim medical issues, different claim potentially mental health issues, different issues with regard to property damage, or the claims regarding the contamination in their home. The other issue that we fired off on was typicality, the idea that the claims of the lead plaintiffs, in this case the Fischers, were similar to those of the rest of the class. We were able to show that they were not. We successfully argued before Judge Rossi Alston that each residence and each resident presented different issues. Again, we argued he would end up with dozens, in that case, of mini trials if a class were certified. So you certainly want to avoid aggregation of claims if at all possible, and it's certainly possible to do that if you're careful in marshaling your evidence to show that, in fact, the residents or the employees or the students have very different claims and issues than the other class members. Let's now turn to the plaintiff's litigation strategies with regard to emotion and junk science. We've covered a little bit of this already. Mold is perceived as gross. As you've seen earlier, we had a picture of mold, and it's something that the jury reacts viscerally to. Juries do not like mold, and they have great sympathy for folks living with mold or other contaminants. As was said earlier, the people who are selected to be plaintiffs in these cases are often attractive and relatable people. Many jurors will personalize and relate to the plight of the alleged plight of the plaintiffs. And many times there's an emotional overlay where there's a claim that the problems with their residence, with their dorm room, with the building they work in, is causing problems with their work. It's causing issues for job performance or promotion. It's hurting their marriage. It's causing a lot of stress on the marriage. It's causing problems with their kids and potential behavioral issues with the kids. Again, these powerful emotional punches that the plaintiffs will pull out and use to try to sway the jury to find for them. And it's very important for us to counter that. And we do it by, as will be described a little bit later in more detail, making sure we present our defense in a way that shows we care, we followed good science, we followed good policies, and that the claims that are being made are exaggerated. Beyond emotion, the plaintiffs rely on junk science. That's a phrase we hear a lot. Junk science is a term that's simply used to describe scientific research or data that is fraudulent or false. In the setting of the work we do defending mold and contaminated building cases, it relates to misleading theories or methods that are presented as a scientific fact but are not well supported. For example, so often we see plaintiffs and their counsel present evidence of air testing that's done in their living space to show that they're being exposed to some dangerous level of mold or other contaminant. But the scientific literature shows that air testing is a completely unscientific and not particularly reliable method to determine mold or other building contaminant exposures. Air testing normally just measuring spores and particles, and in the mold context, it's not measuring active mold. We often see examples with inspectors and experts for the plaintiffs claiming that there's mold in interior wall cavities and that's causing problems. It's unusual that those types of mold in interior wall cavities are going to be impacting the residents on the other side of those walls in the living spaces. And it's a major issue for us to bring in experts, whether it's industrial hygienists, experts in mold, in different types of mold, and also medical issues relating to mold, to make sure we put the proper science in play before the jury, and that we successfully and effectively cross-examine and demonstrate the junk science that the plaintiffs are relying on. You also see on the slide that we deal with causation of medical conditions. Some types of mold have been and are being associated with certain maladies. Typical example would be some mold species will exacerbate existing asthma in children. Some mold species will aggravate allergy-like symptoms. But we have had cases around the country where plaintiffs are claiming that their exposure to mold or other contaminants has caused their children to be autistic, have developmental delays, have caused death, caused Parkinson's disease, cancer, chronic fatigue, suicidal ideation, and infertility. And the list could go on in cases I know Tina and I have handled. It's a remarkable list. And there is absolutely no medical scientific evidence that those types of claims have any medical validity in the scientific literature. And it's critical for us to be able to marshal that evidence, bring in medical experts to debunk that. So for example, in the one case we had where there was a claim that their child's autism was caused by mold, we were able to get that claim excluded because there's absolutely no support for it in the medical literature. But you have to go ahead and get the right experts to show that. So you need to also carefully study all the medical records and what the plaintiff's doctors say about that. And many times they select doctors who can be attacked because of their reputations. All right, so let's turn now to unsupported damages. I'm going to turn it over.
Thanks, Rick. So what we want to do here is take a few minutes to talk through about how, as part of their litigation strategy, plaintiffs' counsel will work through various categories of damages that aren't really supported in a way that they could try to get a fact finder to agree with them. So first, the lost wages or promotional opportunity category. This one is really easy for the other side, for plaintiffs' counsel, to say, look what mold did, look at the impact it had, and that therefore had these downstream effects in the workplace for these individuals. And what happens then is if there are not clear work records that you subpoena or get in advance that you can then use to dispute this story, you don't really have stronger evidence to knock this down. So that category can create its risk because of that proof. We next move to household items, and this one is probably the most frequent. And one of the ways that this becomes much bigger, or a much bigger burden than it seems like it should be, is because the plaintiffs' counsel have relationships with, we've heard about these sham inspectors or mold inspectors. So to be clear, these are usually individuals who maybe have self-educated or have taken a few hours of a course, but they are not certified industrial hygienists and certainly don't have advanced degrees. And typically what they'll do is they'll look at the household items after they've maybe looked at the home as well, and they'll declare that all the household items need to be tossed, or if some may be cleaned, it's not possible, or they will generally disregard the understanding and science about how items can be cleaned, which items can be cleaned. And they won't even look into that. And what we've seen in our cross-examinations of these individuals is they will more or less fold on this point. They'll admit that they were not advising their client, in this case, the plaintiff's counsel, about these different opportunities. And we'll see that although it looks like originally the plaintiff's counsel will say everything has to be replaced, frequently what we're able to do is to get this category of damages substantially reduced as we press on the sham inspector the plaintiff's counsel uses. let's talk about the medical conditions category. And we heard Rick talk a little bit about faulty science or junk science, and we're going to have in 2 months an entirely different session focused just on mold science. So we're just scratching the surface here. But one of the things to understand, one of the key things to understand about the medical conditions suffered, or at least those allegations that are suffered because of the house or building, is there is frequently a story in the evidence that a smart plaintiff's counsel creates. And what I mean by that is they will have the individual in the home, the tenant or the purchaser, not just go to one doctor, not go to two doctors, because many doctors will not write down in the medical record what the patient or the attorney wants them to write, which is mold is making me sick. And after sufficient doctor shopping, eventually the plaintiff's counsel and the plaintiff will find a doctor who writes down something in the record. And usually when they even find that doctor, the doctor might say, patient says mold made me sick. So they still have a barrier to get through. But the point is that this is how plaintiff's counsel will build a medical record history, will look until they can build a medical record history to support this category of damages, because it's such a linchpin to everything else. And when we dig into these records, we find that deposing the doctors has a huge impact. And we also find that there are parts of the record that the doctors, at least the treating physicians, not the hired experts, don't think about that are critical to understanding whether mold, or to what extent mold, can cause impacts, like allergy testing, for example. And in fact, that allergy testing, if it exists, can show a much better alternate causation of an allergy to something else that's much more likely. Now that tends to be used, that medical condition tends to be used as a building block for the emotional damage category. We've talked a little bit about how it's very broad. It's not really tethered to a medical bill. It's not tethered to specific understandings or conditions in the Diagnostic and Statistics Manual. It's generally all of the open, troubling things in most of our lives that we talk about, like stress or fear and anxiety. And statutes permit recovery of this type of damage, even though plaintiffs still have to make a similar showing of causation. But that category of damages is not supported in the same way you might think medical conditions are supported, but can nonetheless be a boon to plaintiff's counsel in the potential overall verdict they're looking for. Finally, the marriage and behavioral issues. This is somewhat related to the others we've talked about, but it becomes part of a theme from the plaintiff's counsel. And the theme that it becomes part of is mold is the root of all the suffering that a relatable family has gone through, science aside. Now, Hal's going to talk a little bit more about that theme.
Thanks, Michael. So every personal injury, toxic tort case, plaintiffs will make it a classic moral story, good against evil. And no surprise who they're going to try to peg as the evil side of the equation here. Landlords, owners, property managers, they're perceived, and plaintiffs will attempt to emphasize this, these are entities that are not easy to like, not easy to relate to as compared to a family with small children. They will call you a slumlord. They will accuse you of putting your profits before your people, or before your residents, or before your workers, depending on the circumstance. They're going to, again, emphasize the disparity in power and sophistication between the resident, the worker, the student, and the owner of the property, who has all these resources and a whole staff. They're going to accuse you of cutting corners to try to maximize your profits. We've seen this in many cases. They will attempt to get you to try to prove the negative. And what do we mean by that? And we give an example here. Many property managers use some sort of software to track, property management software to track resident work requests and work orders, and know when they get logged in, whether it's through a phone, a call center, or a call to the maintenance department, or through an app. We've seen A lot of larger property managers will give their residents apps that allow them to call in a work order, and they will accuse you of not logging those things into your system. The resident will say, I know I called that in. I remember I talked to Joey, the maintenance guy, and told him I needed the mold fixed, and it doesn't show up in your system. So how do you prove that that didn't happen? They will accuse you of deleting work orders out of your system, even though a lot of that software won't allow you to do that. They'll suggest that you, again, as a big sophisticated entity with the control, is trying to hide evidence and deleted out work orders or resident requests. Michael and I had a case where we were dealing with a service member plaintiff who suffered from PTSD and couldn't remember a lot of things, but he absolutely remembered with perfect certainty that somebody, couldn't remember who, told him when he signed his lease that the ducts in his home would be cleaned once a year. Couldn't remember much else, but he knows for certain that that was something he was told. Now, our client didn't have a policy to do that. We had no evidence that anybody told him that, but now we're put in a position of having to try to prove a negative. The other thing that we often see plaintiffs' counsel do, and it's something that requires a lot of advanced preparation, is they will ask your witnesses what I'd call moral questions. Let me give you a couple of examples. Would you live in a home with toxic mold or black mold? Use the example that Rick gave, where there's mold in the interstitial space between the walls, where it's in there. It's not, the evidence will suggest that that mold inside the wall is not impacting the living conditions in the living space. But they'll ask you, would you want to live in a home where there's mold, black mold, proliferating behind the walls? They'll ask the certified industrial hygienist. And that's a tricky question to answer. They'll ask questions like, doesn't everybody have a right to live in a home that's clean and habitable and free of toxic black mold? Answering these questions there's no great answers to them. They're designed to put your witnesses in a difficult position of either seeming callous or seeming hypocritical. And it takes a lot of preparation and careful forethought to get your witnesses ready to try to deal with these kinds of questions that will come up in a deposition or at a trial. And one of the real challenges here is many times a lot of the property maintenance staff are very, very good at their job, but they don't necessarily make great witnesses. So they can go into a residence or an apartment and very quickly diagnose what's the issue and figure out what needs to be done. But describing to a jury how they do their job in a way that's relatable and shows a level of care for the resident there, that's where Rick, Tina, Michael, and I earn our pay. So next, I'm going to turn it over to Rick to talk about insurance issues.
Thanks so much, Hal. I would now want to turn and talk very briefly about insurance issues. We are going to have a complete session on insurance issues, insurance coverage issues later this year. But here are a few pointers. When you're hit with a complaint, if you determine the complaint might fall within the scope of your coverage, you should tender the claim to your insurers immediately. Carrier's duties generally start when it receives notice of a claim. You shouldn't delay in notifying the insurers and requesting a defense. A liability insurer is not going to have any duty and any obligation to pay costs incurred before it's put on notice of the claim. Such costs are almost always deemed to fall in the context of voluntary payments. It's going to be on you. And obviously, though, you'll want to consider self-insured retention issues and be aware that in aggregated cases, it sometimes happens that insurers will argue that each plaintiff and building trigger a new SAR, even though it's all in one lawsuit. You need to be aware of that. And so also when you're thinking of potentially resolving those cases, you need to make sure that you and your insurers have an understanding of how that issue is going to be handled before you start negotiating. Obviously, one of the key issues when you're dealing with your insurer is whether you have a right to choose counsel or whether the insurer will. Whatever the case, make sure your counsel is experienced and knowledgeable in handling the emotional and junk science issues involved in defending these cases. These can be complex scientific cases. They're certainly complex emotional cases, and you need experienced counsel. In any event, you should check your insurance coverage as one of your very first steps. Make sure you're looking at the entire policy. It can be GCL, pollution, environmental policies are typically going to be involved. And make sure you got the correct policy year, depending on whether it's an occurrence policy or a claims made and reported policy. There may be different policy years involved. When you tender to the insurers, you need to provide information to show the claim is within the coverage under the relevant policies. And once you've tendered the claim, the insurer will often respond to an initial tender letter and with follow-up inquiries. It does not behoove you to become defensive or obstructionist at this point. A claims, or it shouldn't happen ever, but a claims representative who's considering accepting coverage will want sufficient documentation, sufficient information in their file to support the decision. You'll want to provide publicly available pleadings and court filings. Offer to set up a phone call or meeting to walk through the claim and answer any questions. It's important to remember that policies will have a schedule of forms, which lists by form numbers, usually found at the bottom right-hand corner of each page, of the various policy components. You'll want to make sure that you review and understand all relevant endorsements, as they often significantly, these endorsements can modify the main policy form. For example, in a case decided last October in Georgia, Nationwide Insurance was found not to have a duty to defend a Georgia apartment complex in a wrongful death lawsuit because the building's insurance policy excluded the alleged cause of the injuries. Since the carve-outs in the insurance policy barred coverage for bodily injury arising out of fungi, bacteria, or pollutants, and the underlying complaint alleged that mold, at least in part, caused bodily injury, Nationwide was found not obligated to defend or cover the apartment complex from those claims. So you certainly want to be knowledgeable about your insurance and make sure that you're providing proper notice and cooperating with your insurer. With that, I'm going to turn it over to Tina.
Thanks, Rick. So we're going to just briefly touch on communication strategies. When we've dealt with some of these cases, I think it's important for companies and property management companies and landlords to really train your employees on the internal communications that they're having about a tenant or tenant issues. And I say that because we've had some verbal and written communications that have come back and been pretty harmful. Some of the emails talking about the tenant complaining again. This tenant is just, do I have to deal with this tenant again? This tenant's making things up. Or the other thing that we see is the tenant has mold in the house. They use the words mold. You want to train the employees on how to have a respectful communication about a tenant and their issues. You want to, because that piece of paper will be questioned. We had witnesses being cross-examined on those internal communications. But also have them also be trained on, instead of writing the words down of mold, you use the words like suspected fungal growth, because we don't know if that's mold or not mold. So training them on the communications. I liked something that Rick talked about is the we care. You want to be able to talk about, and Hal talked about, like, we're bad, we're considered the big bad business. Instead, you want to train your employees on we care. We care about you as a tenant. Let's look into this because your home is our home. So some types of training about that. Then you also want to train your employees when, like, the facility folks are going out to the houses, also having them trained on how they're going to communicate with the tenant inside the residence. We have found that most residents have cameras in their homes. And those residents are recording those when people are coming on site to do facility work. So you want to train your employees and be mindful that there's a lot of times the nanny cam or the recording devices are there on premises. They may not have verbal recording, but they're watching on the on the video recording. Similarly, as we're training our employees, we also need to be training our employees how to have external communications with our vendors. So how to communicate with both the tenants and also how our vendors communicating with our tenants. In other words, again, we care, we're respectful, we're being prompt and responsive. That's a theme you want to be having. It's prompt and responsive and respectful. We care. Then also maintaining good records on the requests. You know, Hal made a good point. We're placed in a position of proving a negative. But if we have good records and we're real-time recording our responses to those requests, so we have the request and we have the response, we can use the same strategy that they're using. Have your facilities folks, your maintenance personnel, when they're going out to do a repair, have them also take photographs of the issue and of the repair. That shows that we are real time also responding and remediating to their requests. Finally, think about creating a tenant portal. Rick, I think, talked about that a little bit with the apps, I think, and giving them the ability to where the tenant can log in. And I'll just give an example where the tenant can log in. Here's an example of a tenant portal. The tenant can do a maintenance request, log it in, and there's the request there. They can follow the status of that request. And then they can see a closeout of that maintenance request. The work was done and it's closed out. So those are just some communication strategies that you can think about. And with that, I'm turning it over to Hal to steps to minimize the threat of litigation.
Thanks. So the steps that I want to talk about, there are a lot of things that we've alluded to, and they're really common sense. And sort of the overall themes that I like to think about are, you know, and Tina, I think, did a great job of emphasizing this. You need to have a culture where it's about taking care of your residents. It's also about taking care of your asset. Keeping your assets in good shape, keeping them free of mold, keeping them free of water damage, fixing roof leaks when they happen. You want to fix, you know, problem when it's a small problem rather than becomes a big problem. It's cheaper in the long run, right? You want to have policies and procedures in place, not only a communications policy, but also a policy for how to deal with suspected mold growth. So, you know, are you going to have individuals that are trained up on what to look for? In many cases, you need to understand what your state and local requirements are. States like Texas and New York have mold requirements where when you're dealing with a certain volume of potential mold in a home, that triggers certain obligations in terms of who can assess the mold assessment, and then typically who can remediate the mold. And they have licensure systems in place where you have to have some sort of license in order to perform a mold assessment. And then typically you have to hire a separate mold remediator because you don't want the assessor and remediator being in bed with each other. And you want to make sure that these policies and procedures that you're putting in place, that your employees are trained on them, and they don't just sit there collecting dust on the shelf after you spend a bunch of time and energy writing that policy. You need to make sure your people are actually following through with it. Again, these are all common sense steps of what you can do to hopefully head off these types of issues. And next, I'm going to turn over our last poll question. This is, again, so we are able to collect CLE credit for those. So if you all could take a second of those kinds of policies and procedures and things that we talked about in place, please check if you have any of these. So please check A if you train your staff. Please check B if you have maintenance policies and protocols. Check C if you have a plan in place if there's suspected mold growth. Please select D if you understand the mold remediations that are applicable in your jurisdiction to your assets. And E for other, and F for nothing. And I'll just, again, give it another moment or two. Again, we really appreciate everybody. We realize we're up against the top of the hour here, and thank you all for staying on. Looks like we have about half of people that have responded, so let's take a quick look at the poll results. So it looks like, most folks have done something. So hopefully if you take one takeaway from this is think about maybe filling those gaps in some of these areas that you haven't thought about before. Next, I'm going to, turn it over to Rick, and we'll sort of go questions and wrap it up.
Thank you, Hal, and we certainly welcome answering any questions you might have. We always appreciate questions. We know we're kind of up against the hour here, but go ahead. If you send questions, we'll stay on and respond to them. We also want to let you know that this is the first of 6 sessions we will have, and we will be sending out emails as we set these dates. You can see we have another number of subjects we're going to be covering over the course of this year, and we look forward to continuing to bring you information about this. So I'll stop right there, see if there are any questions at all. Well, in any event, thank you for joining us today. We hope the information was helpful to you and your organization. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And please be sure to complete our short survey. We cherish your feedback. We use the feedback to plan our future programs and make sure they're going to be applicable to your business needs. Absent any questions, this concludes our webinar. Thank you so much for joining us.